Okay, I think we are all ready to go. I see camera lights on in both places being recorded, and it appears now that we are being streamed. Is that correct, Mandy? We're not. The camera's on, but we're not streaming through the broadcast. I have it. Thank you very much, and welcome everyone. For the record, the date is Tuesday, the 24th of September. The time is 9:30 a.m., 9:32 a.m. The place is the Bollinger Room at the Office of the Montana Public Service Commission. As the practice started last week, we will now begin our meeting with the Pledge of Allegiance. Please stand. I pledge allegiance
to the flag of the United States of America and to the republic for which it stands, one nation under God, indivisible, with liberty and justice for all.
Thank you very much for that. And as our common practice, we are offering an opportunity for public comment. Anyone in the public would like to make a statement, and I do not see anyone here, so we'll move on to our action items. First action item is the approval of minutes. Do I have a motion? Do I have a motion? And a second. We have a motion and second to approve the minutes. Is there any discussion? Hearing none, all those in favor signify by saying aye. Aye. And for the record, today in the room we have Commissioners Koopman and Pinocci, and myself, Bob Lake, is sitting as the chair today. Commissioner Johnson and O'Donnell are unable to get a connection and are excused for the day. And seeing no further action items, we'll move into the work session for the day. First work session, docket 2019.04.023, the recertification of eligible telecommunication carriers. Like, very easy to say. Mr. Dalton.
Thank you, Mr. Chairman. Good morning, Commissioners. Docket 2019.4.23 is a PSC-initiated docket that was open to facilitate the recertification of eligible telecommunications carriers in Montana in order to allow those carriers to continue to participate in the federal high-cost program. Last week, staff circulated a memorandum which provides background and a staff recommendation in this docket. As the memo explains, all carriers requesting recertification have filed the required sworn affidavit from a company officer and FCC Forms 481 and 690. Staff has reviewed the information filed by the companies and finds that all carriers have met the requirements needed for recertification and has no reason to deny their request. As such, staff recommends the Commission approve ETC recertification for all carriers and their respective study area codes, which are detailed in Appendix 1 to the staff memorandum. Thank you, Mr. Chairman. That's all I have, and staff is available for questions.
Do I have a motion?
I'll make a motion to accept staff recommendation.
Is there a second? I will second that. Is there any discussion?
I'll defer to the movant if Commissioner Pinocci would like to begin. Otherwise, I did have some questions of staff.
I see no questions. Commissioner Koopman, the floor is yours.
Thank you. Thank you for the thorough memo, as usual, staff. Boy, you guys look sharp today. A couple of questions, and then maybe a brief comment. The challenge I think that the commission has, the frustration that the commission has and staff has with these recertifications each year, as you know, is that we recertify with limited information. We have copies, and I assume for all the almost 30 ETCs that we would be recertifying together here, of the two FCC reports, and then also, of course, the affidavit that state law requires. But that leaves so much yet unknown. As the memo points out here, there's basically 5 areas. I won't go through them, but 5 areas that that the 2 FCC forms cover, and it's worth noting that in none of these areas does it really get to whether there is misuse of these federal funds based on what they're directed to be used for, earmarked to be used for, and it seems to me the only way that this commission could get that information, be able to actually put, and I thought in our last work session that Commissioner Vice Chairman Lake had made some very poignant remarks on this, that we really don't have full information at this point to easily recertify one or recertify all of them, because we simply don't know, and we don't have the staff coverage to be able to, and this is a long question, I'm sorry, to be able to review how they're actually spending the money, actually track, monitor, oversight of that money that we're then saying next year, yeah, you did a great job, we're going to recertify. So without auditing, and we don't have the staff coverage for that, without our own reporting requiring a report that's much more extensive than the 3 things that we do get. So apologize for the long question, but staff, what are we supposed to do, and how, on a basis of just personal integrity, can I put my hand to approving recertification when I just simply don't know? And by asking that question, I'm not suggesting that there is wrongdoing. I just don't know. What do you suggest? How do I get over that hump?
Vice Chairman Lake, Commissioner Koopman, I understand your concern, because the human capital that it takes to look into every ETC and investigate their use of federal universal service funds on an annual basis would be overwhelming. And how staff has approached this issue is that we conduct initial diligence on a ETC carrier's application for designation, and once a carrier has overcome that first initial hump, then we maintain a systems normal, a status quo annual certification and designation, unless we have allegations of abuse of universal service funds brought to our attention. Obviously, the relevant example now is with Northern Telephone Cooperative. But outside of allegations brought to us, we're in a position where we examine what they provide to us, and unless something looks out of the ordinary, that we recertify. And it's I think a helpful balance between the resources we have available at the commission, where we couldn't do a full-scale investigation, but when credible allegations are brought to us, we do investigate those fully. And so that's I believe, my perspective on it.
And Mr. Chairman, Commissioner Koopman, I guess I'd just add that, I understand your concern. I think I'd just add that, these carriers on legacy support are indeed audited by a third-party auditor before their cost information is submitted to NECA. NECA also audits their cost information. And then carriers on model-based support have deployment obligations that they need to meet. So when they receive that money, they have to prove that they've deployed broadband to a specific number of locations. So it's almost like the proof is in the pudding with regard to deployment. I don't know if that helps you at all, but we're not the only entity looking at these companies with regards to high-cost funds.
USAC, for example, is looking at the way the money's spent.
Commissioner Koopman, yes, that's correct.
Yeah. And of course, that we won't get into it now, but that would support the argument that maybe it should just be the federal government doing this that has the resources, and it's their law, their program. But I understand what you're saying, and we're just caught in a situation where we want to assume that they're all doing the job right, but we just simply don't have information in our hands that's as complete as we would like it to be. And because they qualify initially for certification, doesn't mean that necessarily they're going to qualify for recertification. It's a challenge, and it's something that I guess I take seriously, putting my stamp approval on something where I have limited information. Another question I have would be if we did not approve this today, and it would ultimately still default back to the FCC. In other words, each of these carriers could then go to the FCC and still get approval, but there would be obviously some delay in that. Would that, at this point, create any hardships on any of these companies if they did have to appeal to the FCC, or is there enough time to where there isn't going to be a break in their support?
Mr. Chairman, Commissioner Koopman, I guess it's not always been totally clear to me that these companies can appeal to the FCC and request ETC recertification. State law says that we need to do it, and that's about as much as I know as far as where they get ETC recertification from. But I guess I'll say that as far as a break in their support, what we're doing today is asking for them to be approved for support beginning in 2020. So that's when the support would begin. So I suppose there's a couple months between now and then that if they can appeal to the FCC, then that's the amount of time that they would have.
Another question I have goes to, I guess, the potential of amending the motion. One of the things we've discussed in end docket in the past, and it's been I suppose kicked around but never brought forward in a work session, is the possibility of us requiring additional reporting to make our certification process more robust, and I would say more legitimate, if you will. Can I offer an amendment? This, I guess, is a legal question. Calling for a rulemaking session to require an additional PSC reporting process added to what we have now, which again is limited information. Am I able to do that with this particular docket, or does that have to be done a different time?
Chairman Lake, Commissioner Koopman, you have the right to amend the motion to order a rulemaking in the future, because that rulemaking wouldn't impact the current certification process, and so there's no due process concerns with bringing it up. And then, importantly, if and when the motion were to pass, and if the rulemaking were to be moved forward, all parties would be able to participate in that rulemaking, and so they'd have the opportunity for notice and opportunity to be heard. So, well within your rights to do.
Thank you. I am going to, Mr. Chairman, then make that motion at this time. I will have one other comment at the end of our discussion, but I would like to offer an amendment that we commence a rulemaking process to require additional reporting. I'll leave it very nonspecific at this point, where the staff can generate draft rules, and we go from there. But anyway, my motion is to amend the motion to commence a rulemaking process for additional reporting required in recertification, Mr. Chairman.
Is there a second? Hearing none, that motion dies for lack of a second. And just a question on that, Commissioner Koopman. I think I heard you say that we deny the recertification and then open the undocket. Since this is an annual event that we approve these on an annual basis, would you want to, after the, if it is approved, would you then want to offer a motion to open an end docket to have that study so it's ready for next year? Because that's not going to be a short process. It's not going to be something that's could be completed in a very limited time.
Mr. Chairman, I apologize if my motion was misunderstood. This was a motion that would only be significant if the amendment, if the original motion passed. So it wasn't with the condition that we deny the certification, but it's an amendment to the motion to support the certification, approve the certification.
Well, Commissioner Koopman, could I make a suggestion that we vote on the approval for this year and then in a separate motion open an end docket? Mr. Regalo, would that be a proper direction for us to take on this?
Chairman Lake, Commissioner Koopman, I think both options are fine. And you can either take your recommended suggestion where we continue with the original motion to approve all ETCs, and then in a subsequent motion consider a end docket, as we have described it historically, to have a rulemaking to address additional ETC reporting requirements. Or we could take Commissioner Koopman's approach where we amend the initial motion, we keep the recommendation to recertify all carriers, but we also add on the direction to staff for a rulemaking to discuss options as well. Both work.
Okay, and I appreciate that. Thank you. I think I would prefer if we just kept them separate. Is that okay, Commissioner Koopman?
Well, I have a question, Mr. Chairman, of Mr. Regala. Can I make a motion on something totally new that hasn't been noticed as a work session under new business or something? It seems like I've never seen that on the commission that happen. But simply by amending this motion, it accomplishes exactly the same thing without that question being raised.
Vice Chairman Lake, Commissioner Koopman, I think you bring up a good point that the current work session didn't notice any potential additional requirements, but we routinely consider additional motions or additional conflicting motions than what was noticed to the public. And so as long as it's within the realm of reasonable notice to the general public, then that motion is permissible. But I do agree with you that your initial approach does not present that concern compared to Vice Chairman Lake's, which separates those two. But I still want to be clear that I think both approaches are well within your rights to do.
Well, and thank you. And, Mr. Chairman, the reason I would want it to be an amendment, frankly, is if the amendment, if the commission is not amenable to my amendment and to having a rule-making session, then on final passage of this motion, I will vote no. That will guide my my vote ultimately on the motion that's on the floor. So if I can't get a second, then I will vote no on the motion before us. And if I may offer a short explanation for that, Mr. Chairman.
And I appreciate that, Commissioner Koopman, and I want it to be as neat and clean as we possibly can, as long as the motion is included to to pass the certification for this year that's in front of us, and at the same time open an end docket to study the role of the commission in the future, as to, and that in the future would be a critical terminology. We don't want it to back up and stall this one before it goes forward. And that was my concern, that we would not have this certification completed right now. So, Commissioner Koopman, what is your pleasure?
Let me
Lead the direction.
Let me make the motion again. Then I would move to amend the current motion on the floor to include a call for a rulemaking process to create the consideration of additional reporting for future recertifications, and my amendment does not block current recertification in any way.
Mr. Regala, I see you wanted.
Vice Chairman Lake, Commissioner Koopman, I just want to recommend a process forward because I can imagine several issues that we can avoid if we discuss the process now. Would you be open to having your amendment to the motion direct staff to research additional reporting requirements and then come back before the commission for a subsequent work session, so that way we can actually get direction on what types of reporting we'd be looking into? Because I could see the universe of reporting requirements that staff considers might not be on point with what the commission is considering. And so I'm curious if you'd be open to an amendment to that effect.
I don't mean to be difficult here, but that doesn't give me any surety that the commission ultimately will approve a rulemaking process. I absolutely agree that staff needs to develop the drafts, and then we'll go through that in the process. But it's certainly possible that the commission, when that work session occurs, if we do it the way you've suggested, will still reject having the rulemaking. So I don't know. This has gone on a bit too long. I think what I'm sensing is that the commission is not real receptive to this idea, and I do plan to vote no on the motion, and I'll explain a little bit why before the vote.
Commissioner Koopman, my personal feeling on this, and this is my personal, is that I believe we do need direction for the future on what is our role, how is that role exercised, and how far can we go in that investigative process. It may be something as simple as us receiving the documents that are sent to the FCC, and once we have those in hand, that may suffice. but I'm willing to support the terminology that Mr. Regala has offered, which basically is let's know what we're asking for before we open the docket, so we don't get in and have a docket opened without a true direction for it. So I had the direction. Mr. Koopman, it's up to you. Which way would you like to go?
I have no motion.
Okay, so that motion's been withdrawn. Any further discussion? Hearing none. All
Mr. Chairman, I do want to
excuse
just state very briefly why I am going to vote no, and I'm sure this will pass. And I'll try to be as brief as I possibly can. I think, as this commission knows and staff knows, I've had concerns about this program from the very start in terms of the public interest, in terms of the supreme law of the land we call the Constitution, that we just talked about recently and just celebrated in Constitution Day, which ultimately guides everything we do. And And even though, we don't pass laws, we do need to be cognizant of what is the proper role of government at all times. And I not picking on the staff, but just simply respectfully disagreeing with staff. The comment is made, and I think it's a comment that's generally believed, and it's what propels this program forward year after year with more and more money being devoted to it. Under background on the first page of the staff memo, second sentence states this: high-cost program provides funding to telecom carriers to provide service in rural areas of the country where the market alone, pardon me, getting a cold, where the market alone cannot support the substantial cost of deploying network infrastructure. No, I don't believe that. But the most important thing is not whether I believe it or not. I mean, every time the government steps in with an expensive program that never goes away, it's always with the justification, market failure, market failure. And I have asked every expert that has ever come before us, has there ever been a study done to show what people in rural areas would be willing to pay for this service? And it has never been done. Nobody has ever been able to prove that point. It is simply an assumption that justifies the program. And I personally don't believe it. I think if it's something that people want, people are willing to pay more up to a certain amount, and we don't know what that amount is. I do know that from what I've read, the typical additional cost for the cost of service of putting it, of deploying these into the high cost areas might be another 50%, maybe as high as double, but typically maybe about half again more. And the question simply has to be asked: if folks don't value a particular service enough to pay the cost of that service, the true cost of that service, then is it a proper role of government for them to go to government and say, make the other person pay? Make the other person pay. I'm not willing to pay that much. I'm not willing to pay what the cost is, true cost is for this service. Make them pay. There's a word for that. It's called socialism. It's socializing cost. It's taxing the many to benefit the few, and it always looks like government has created something out of thin air that's a benefit to all. Well, it's just shifting costs, and I don't believe that is ultimately what government ought to be doing. So I've had real problems with this, particularly because there never has been any firm study ever done to prove that ultimately these people would not opt for paying more. And if they're not willing to pay more, I see no moral or legal justification for forcing other people to pay what they're not willing to pay. Again, it's basically the classic example of a socialist approach to a situation. So I am going to vote no on this. The other reason, obviously, is because we do not have the information in front of us to be able to truly verify that these ETCs are all complying with the law, and that they're using the money the funds, the many millions in funds, according to the requirements of federal law. And without that reliable information, I can't put my hand to this. So for those two reasons, I am going to vote no, Mr. Chairman.
Thank you, Commissioner. We'll go to the vote. All those in favor of the motion to approve the ETC filings for this year, signify by saying aye. Aye. Opposed?
No.
Motion passes 2-1 with Commissioner Koopman dissenting. And just to inform the people, we have an additional item to go on our work session for the day, and it'll be coming in number 4 position, and it's an out-of-cycle work session dealing with the MDU request for an interim relief on the gas rates. With that, we're moving to item number 2, docket 2018.01.005, Marymount complaint against Northwestern. Mr. Regalo.
Thank you, Chairman Lake. Commissioners, this is a little bit of a celebratory work session. We get to amicably resolve litigation, which doesn't happen very often in our line of work. You'll remember that Amerimont brought a complaint against Northwestern alleging a variety of Territorial Integrity Act disagreements. Northwestern moved to dismiss the complaint. The commission, on a split vote, denied Northwestern's motion because we felt we had jurisdiction to investigate the complaint. Northwestern filed a motion for reconsideration. We denied that. They took us to court. The district court actually found for Northwestern and found that we didn't have jurisdiction to investigate the Territorial Integrity Act agreement issue because it wasn't brought to us mutually by the two parties. Two parties were Vigilante Electric Cooperative and Northwestern Energy. So the district court directed the PSC to reverse its initial order on Northwestern's motion to dismiss and the commission's subsequent procedural order starting that docket. Amerimont appealed, and the two parties reached a settlement before the Montana Supreme Court dismissing the lawsuit. I spoke with attorneys for both Amerimont and Northwestern just before the work session today. They're both happy with the resolution. They're considering at least two different options to resolve this in the future. One of them will entail a filing before the commission, but again, they're considering their options here. But I would anticipate something before us, a joint application with some sort of transfer of lots. But again, that'll remain to be seen in the future. So staff's recommendation today is to do what the judge told us to do, which is reverse orders 7603 and 7603A, but also reverse 7603B, which is our order on reconsideration. That was finished, that order was released after Northwestern filed its petition for judicial review, so that was not included in the order, but it's necessary to reverse. So it's a long way of saying we don't have to litigate anymore, so staff recommends approval.
Commissioner Koopman, would you care to make a motion?
Yes, Mr. Chairman, and I will. This is in my district, of course, and I've been concerned about this all along. There just really needed to be some coming together, and I appreciate the work of Tina and her people on this as well as we tried to work this through over time. And so, if they're happy at this point, we're happy because there was a definite problem, in my opinion, that needed to be resolved. One question I did have before I make the motion, Zach, is why I would prefer that rather than we reversing three orders, which I think the orders were in good faith and were wise by the commission in not allowing dismissal originally. Why couldn't the complainant, Amerimont, simply withdraw their original complaint?
Vice Chairman Lake, Commissioner Koopman, that's a good question because with an amicable resolution between the parties, an easy way for this docket to be resolved is for Amerimont to file a unilateral motion to dismiss, and then we don't have any jurisdiction over the complaint at that point. Another easy way to do it is to just follow what the judge directed us to do. I don't have a strong preference either way, except for the fact that we're here today on a recommendation to dismiss as directed by the court. But that being said, we could open it up. We could delay that work session today, and you could direct staff to reach out to Amerimont and have them file a motion to dismiss. But either way, it gets us to the same point, which is amicable resolution, which is a good thing. So.
Okay, well, thank you for that. And yeah, I would actually prefer that they simply dismiss their complaint, but I will make the motion recommended by staff, and then if the commission would prefer to go the other route, I wouldn't have any problem with that either. But I will move, Mr. Chairman, that we reverse orders 7603, 7603A, and 7603B.
Is there a second? I will second that. The trouble is, if we don't go this way, what the court told us, then all of a sudden we still have it in front of us and nothing has changed. So the best way to do is put it to bed and move forward. Is there any further discussion on the motion? Hearing none, all those in favor signify by saying aye. Aye. Opposed? Passes unanimously. Moving on to our number 3 item, Northwestern Energy Supply Resource Procurement Plan, their motion for a protective order. Mr. O'Gallo, that's trouble when only one of you show up for work.
It is too. And Vice Chairman Lake, the theme of this work session is getting what you want, but not why you asked for it. And the reason this is Northwestern filed a motion for a protective order requesting protection of third-party proprietary information. They're arguing that information qualifies as trade secret under our protective order regulations. Staff does not believe that Northwestern has standing to assert a trade secret right that's not theirs. So on those grounds, we deny the protective order. However, we grant the protective order for our otherwise legally protectable standard. And that applies to this motion because the information involves certain modeling and operating cost information from these third parties. This motion concerns Northwestern's resource procurement plan, and part of their plan is modeling different generating resource operational and cost information. And a part of how they do that is they reach out to their third parties to get them that information. Well, there's very few generators in Montana, and by aggregating their information into a table, you can look at the table and say, oh, that must be Whitehall Wind. Oh, that must be Crazy Mountain. And so as a part of requesting that information of these third-party providers, Northwestern said, if you're concerned about your trade secret information, let us know, and we will request a protective order before the commission. And so what that does is create a contractual right where if they break it, they're subject to litigation risk. And that falls within our otherwise legally protectable protective order regulations. This has been an issue that we've dealt with 5 or 6 times in the last year, where parties are seeking protection from someone else's trade secrets, and we've followed this same approach. And so we're trying to signal to the regulated public that this is how we would like protective orders to be dealt with in the future. So staff would recommend granting for other grounds Northwestern's protective order, specifically under otherwise legally protectable, ARM 38-2, 5007, 2, and 5. Staff's available for any questions.
Do we have a motion?
I'll make a motion to accept the staff recommendation.
Well, it's been moved. I'll second that. Any discussion? Commissioner Pinochi, was he?
Mr. Argal, I just have to say, good legal work there. I'm thinking that Northwestern ought to appreciate the free legal advice that we just provided. But good legal work, and yeah, I support the motion.
Mr. O'Gallo, is it their interpretation of our requirements, or is it the standard within the legal profession the standards of protective order that's causing this confusion? Are they trying to follow a particular terminology inside that definition of protective order qualification?
Vice Chairman Lake, I haven't spoken with any attorneys who file protective orders before us on why this approach keeps occurring, but my guess is commission practice is one point where in the past we would grant these when it would be a third-party protective, it would be a third-party trade secret, and we've granted it when the first party requests protection. So I think that's a big factor of why these protective orders keep coming in front of us. Second, I think our regulation is overly complex in terms of what the protective order requires. And so there's definitely opportunity for us to revise our protective order regulations. And it's on legal's radar to revisit those in the future. And hopefully when we get back up to full steam with the next attorney coming on board, we can move forward in that direction.
I think that's a good way to look at it, is if we have something in our at least our definition of what a protective order covers and how you get qualified for it. So I think since we've had several of these, it's probably advice well taken that let's take a look at what we're asking for and get it right. Further discussion? Hearing none, all in favor signify by saying aye. Aye. Opposed? Passes unanimously. With that, we'll move on to item number 3. No, we're on to item number 4, the out-of-cycle work session, MDU's request for interim relief. Mr. O'Gallo.
Thank you, Vice Chairman Lake. This one is a out-of-cycle work session because MDU requested effective rates on an interim basis, October 1, for services rendered on and after. Our next work session is October 1, so to avoid any complications with ordering something the day of, we needed to bring this before the commission as a out-of-cycle. This involves MDU's Rate 88 tracker, which is in its natural gas portfolio, and MDU's interim requests a increase to residential, general service, small interruptible, and large interruptible customers. And that increase is based on the unreflected gas cost adjustment from the last year. So last year we came in and we set rates at a certain level. That level has resulted in a balance that MDU has not recovered from customers. So we're taking last year's balance, setting the rate a little bit higher so they can reflect, so they can recover that balance. And then we're also today authorizing a monthly tracker that tracks rising fuel costs every month. So we're taking care of what happened last year, their deficit, and then we're allowing them to track going forward on a monthly basis. Staff recommends approval on an interim basis, and the only wrinkle in this process is Senate Bill 244, where we don't know what we can do with trackers going forward. So having an interim will maintain the status quo while we resolve that issue. Staff recommends approval, and we're available for any questions.
And the interim rate approval, quite frankly, is no risk to the consumer, because if it is incorrect, there is full recovery with interest, correct? Okay. Do I have a motion, please?
Make a motion to adopt staff recommendation.
Okay, well, it's been moved. Second? I will second that. Commissioner Pinocci, do you have a comment? No comment. Commissioner Koopman? Hearing no further discussion, I'll call the question. All those in favor signify by saying aye. Aye. Opposed? Carries unanimously. With that, we're going to close our session in the Bollinger Room and move into a closed session. We will not be broadcasting or streaming from that, and appreciate everyone here. And we are in recess, meeting in the Commissioners' Conference Room at 10:30. Thank you.